The final matter to come before us this morning is in re GD and GD. The applicant has waived oral argument this morning. Counsel, you have 15 minutes to present argument. We've read the briefs. We're ready to see when you are.
May it please the court. My name is Denise Ferguson, and I am here on behalf of James Zakola, who is the father of GD and GD. I would like to start with the matter that I brought up on page 10 of my brief, which deals with the fact that this court has dealt with docketing on a lot of different levels when it comes to juvenile court matters. When I looked at the docket for the boy GD, let me just put it that way, there was no motion for permanent custody that was ever docketed in December of 2014. I don't know why it wasn't docketed. It shows that something was served at that matter at the end of December, but it doesn't show what was served. It doesn't show that anything was filed for GID. GED, a motion was filed and docketed, but not GID. A court, according to this court, cannot take CSB's word when it comes to service of a motion. In the beginning of this case, they took CSB's word that what was filed or what was served upon father was a motion that for all intents and purposes was never filed for GID. Granted, what that does is it makes a dichotomy of these cases. It bifurcates them. So even if GED's case would stand, because that was docketed, both the filing and the motion, and even if the court would disagree with me on all of my other arguments, for GID, no motion was ever filed. Father's attorney did show up. He did participate because the trial was supposedly for both children, and Mr. Zakola had a right to be defended on behalf of GED. The fact that GID, though, did not even have a motion filed is an issue, because you cannot go forward on a permanent custody motion, and there cannot be a finding that such a motion was filed, which gives rise to permanent custody on that child.
You're saying there's simply no jurisdiction?
I'm saying there's no jurisdiction on GID.
Right.
On GED there was.
Right.
And even if this court wanted to look at the prior motion that was filed, that did not raise findings upon which the court in this case found permanent custody to be granted for GID. So I do believe the court was without jurisdiction for GID. Now, the other issue, the next issue I'd like to discuss is the statement given by the foster parent, the foster father. At the end of the trial, after all of the witnesses testified, as somewhat of a closing statement, the foster father was allowed to get up and give a statement. The court stated that the law allows such statements to be made by foster parents and to be considered. I have searched high and low for that law. I have not been able to find it.
Now, let me see, make sure I understand. The foster parent for which of the children?
For both
For
children.
both children wanted to make a statement, and you're saying the case law says that someone who is an appropriate foster parent cannot make a voluntary statement or cannot make any statement.
Well, statute says he cannot make an unsworn statement. A foster parent at a permanent custody hearing, according to statute, is allowed to present evidence. Okay? If they're presenting evidence, then the rules of evidence apply. They're allowed to participate in that manner. It does not give, according to RC 2151-424, it does not give them the right to make an unsworn statement that can be taken into consideration. And the court,
So was this a simple neglect and forgetting to take a sworn statement? If you can tell from the record.
no, it was not. Because the court stated, and before we close, Mr. and Mrs. Williams, those are the foster parents, I know you have been here throughout the trial. The law does allow you to make a statement, although you're not required to do so. If you would like to, you're welcome to make a statement at this time. That's exactly what the judge says. And then immediately the foster father started speaking, only that we are the foster parents, we have loved on the children to the best of our ability, and we understand that we are foster parents first.
And so assuming that was done, what is the prejudice to your client?
Well, Your Honor, the judge referred to that statement in the decision. Because the foster father continued, if for whatever reason the court should deem it necessary to grant permanent custody to the state, the children will have a place to call home.
Now, was that sort of generic situation and testimony elsewhere provided by other witnesses during the proceedings?
Not that I'm aware of.
Okay, thank you.
I thought the GAL said something similar.
I'm sorry?
I thought the GAL said something similar.
Well, a GAL statement is not allowed to be taken as evidence.
Well, they make a recommendation.
They can make a recommendation, but they're not allowed to take what the GAL says as a form of evidence that this is what the foster parents want.
Okay, and say I agree with you. How do we know that the court took the foster parents' comment or statement as evidence?
On page A3, they state, the children have been in the same foster home throughout their lives. This is the only family these children have ever known. They hope to adopt the children if permanent custody is granted.
But what I'm saying is, what I'm saying is, how do we know that's evidence from the foster parent? Because they didn't say that either. That's not what he said.
Well, they said they'd provide the children with a home. But nobody else testified that.
So what I'm saying is you may have a Lyden saying something that you say is not evidence. You may have the foster parent saying something that's not evidence. How do we know the court relied on which one? Now, according to you, they're both error, but you only raise error in regard to the foster parent.
Well, because the foster parent was unsworn and no one got to cross-examine him or ask him any questions at all.
But the GAL, you're saying, if they provided that evidence, it's not, provided that information, it's not evidence either. So what I'm saying is, how are we supposed to know which one the trial court relied on, if either?
Well, they would both be error. I cannot, seriously, I cannot recall at this point in time if the GAL actually testified to that.
Well, obviously, we'll look at everything. I was just wondering, this is your opportunity to tell us what you think about those issues.
The big issue with the foster parent statements is they happen pretty much every permanent custody trial that I've ever been in at juvenile
I've
court.
read them in the transcript too, right?
And
I don't know that they happen all the time, but I've read them before.
they're never sworn, and unless CSB has called the foster parent for a witness earlier, no one ever gets to cross-examine. But they're given weight, and it was given weight here. The other thing that happened is, with the rules of evidence, the foster parent presented pictures of the children to the judge. And it was taken in as not an exhibit, but it was taken in and looked at by the judge. And it was not properly admitted.
So it's not in the record?
I do not believe so, but there is, in the transcript, there's mention of, I'd like to present these pictures to you. Oh, okay, bring them up.
So let's assume they're not in the record and we can't look at them. What's the prejudice with the court seeing a picture of the children?
Well, the prejudice is this father lost custody of his children to the agency who are going to let these foster parents adopt. And they were allowed to come in without proper foundation. They were allowed to be used as an emotional key for the foster parents. And while I would almost be guessing what was in the judge's mind, because she did not refer to them, I believe it's prejudicial to allow items to be presented to the court that tangentially relate to the court, or relate to the case, but do not have the proper foundation, or not following the rules of evidence, have not been presented. And while it's a plain error, or a structural error when it gets into not following the rules of evidence during a permanent custody. I hope that answered your question.
Thank you.
The only other thing I would like to bring up is Father's trial counsel of this case failed to file for his client to participate in any way, shape, or form. He showed up the morning of the permanent custody trial, said, I have a phone call, or I have a phone number, can we try to get my client on the phone? They had the wrong phone number for the wrong prison. The judge commented on that this should have been set up prior. And the attorney said, yeah, maybe, but I'm trying to do it now. In N. Ray KT in this court, it came out of Lorraine. I wish I had the site, I'm sorry. It was one of my cases, though, that I did from Lorraine. The attorney in that case failed to file to have her client transported. And this court said that was ineffective assistance because she did nothing in order to try to secure her client's participation in a permanent custody trial. This attorney waited until last minute, literally after the opening arguments were done, to ask the court, can we try to get him on the phone? And the court even responded to that with, this really should have been done earlier and we may have been able to do something. The judge had her bailiff work on it and did apparently get the client on the phone by lunchtime, after half of the trial had gone. I believe it's ineffective assistance of counsel that the trial counsel waited that long, did not talk to his client prior to the trial starting, could not talk to him on breaks, which he could have done before every witness if he had filed to get that participation. And we would ask that it be reversed on those grounds. Do you have any other questions for me?
Seeing none, thank you.
Thank you.
Thank you for your presentation this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to all sides, as well as posted on the Ohio Supreme Court website. We are adjourned until Thursday in 7 o'clock.